First question was about recalling staff and the employer in particular. So what are our rights as employers? Do employees have to come back if we ask them to? We don't want to breach human rights. This is one of the concerns that we have currently right now. So some of us may have more senior staff. Some maybe have a spouse who's already earning income. So maybe we don't feel as bad for them. How is it best to do this? And is there like a recall letter that we should use?
Okay, so it's going to be a long answer. So if it ends up being too long, Azim, you get to do one of these. Just say, Maniza, stop, slow down. So I'll keep an eye on you.
Okay. I'm going to let you do that, okay?
Okay. Okay, so loaded question, great question. So because we're talking about a non-unionized context, there's technically nothing that precludes you as employers from recalling your employees in a manner that you see fit. So if we were talking about unionized employees and their seniority that comes into play, so as crass as this might sound, with respect to you recalling your employees, recall the ones you like best first. So the ones that are the most productive, the ones that, are the most reliable, those are the ones that technically you should be recalling first. And there's nothing, legally untoward about doing it that way. Now, if you've laid off your employees, you've either done one of two things. Either you have benefits for your employees, in which case you've laid them off for a maximum of 35 weeks, because you've continued their benefits. Or if you do not provide benefits, you've laid them off for a maximum of 15 weeks. So there's no legal standard that says that you need to recall them by way of giving them a letter. Now, with all of that being said, it's always good practice to, paper things. And what I mean by that is ultimately, if somewhere down the line you have an employee that takes the position that I wasn't recalled, or I wasn't recalled under the appropriate set of circumstances, or I raised a concern about my recall, if you have it all papered, it's always better for you. It doesn't need to be some overly convoluted document, but something simply as, the company's financial health has taken a turn. We're attempting to recall employees in stages, if in fact that's what you're doing, and we'd like to recall you back to full-time employment. Now, there was a second part to your question that spoke about, well, what if your employees don't want to be called back? So if you have an employee, and my sense is, just because we've done a few of these workshops and these questions come up over and over again, that this is probably not the only time we're going to be touching on layoffs. But if you recall an employee and the response is that I'm happy to come back to work, then great. But you might get a response that is, I don't feel safe coming back to work. I understand and I appreciate that you've done all these, things from an objective standpoint that are outlined, as various advisories coming down the pipeline from the provincial and the federal government about social distancing. And where social distancing is not possible, you provided appropriate protective gear to keep me safe. And things are being wiped down repeatedly and everything is clean. But notwithstanding all of that, I still don't want to come into work because I don't feel safe. In those circumstances, you don't have to be perfect. You just have to be reasonable. So maybe some of you have already run into this issue where you've tried to recall and you have people saying that I'm not feeling comfortable coming back to work because I'm still afraid that I'm going to be exposed to this virus. And of course, you cannot guarantee that they won't be. In those circumstances, you say, look, either you come back because we've recalled you as per our rights under the Employment Standards Act and our obligations under the Employment Standards Act. And if you don't want to come back, even though we are quite comfortable with the measures that we've taken in the workplace as far as keeping you safe, then either it's a resignation or it's a job abandonment. So if you are ready to recall them, they have to return. Let me tell you very quickly about a narrow set of circumstances under which a recall, they may push back against a recall, and their pushback may be something that you need to accommodate. So you might have an employee that says, look, I am not comfortable coming back because I have children who are young. I don't have childcare. The daycares, as we all know, are not still up and running. There's no school. So notwithstanding the fact that the business is operating and you're ready to take me back, I can't come back because I have no one to look after my kids. So that then, and I say human rights, Azim, because that's what you have triggered first, that then potentially would trigger your rights under the Human Rights Code, which tells you as an employer that you have an obligation to accommodate somebody to the point of undue hardship. So in those circumstances, that may trigger your obligations under family status, which means that if it was me, Azim might say to me, okay, Maniza, you're a great employee. We'd love to have you back, but we appreciate why we can't have you back because you have to care for your young children. And those circumstances, what Azim would have to do is provide me with a job protected leave. Now, that doesn't mean I have to be paid, because if I'm not there doing meaningful work, then I don't need to be paid. But that does mean that, once my kids are back in school, I have the right to come back to work. Now, that might make things a little bit complicated for Azim, because now he has to look for somebody to fill in the role on an interim basis, on a short-term basis, which may be difficult, although maybe not so difficult in this precarious job market. Another set of circumstances which have arisen repeatedly with our employer clients is we have, they may potentially be an employee that says, look, I can't come back to work because I'm living with someone who's elderly, I'm living with somebody with a compromised immune system, or who may be more susceptible to the most adverse effects of, contracting this virus. Again, it's always on a case-by-case basis, but there may be circumstances under which you need to accommodate certain employees. And I would say reach out to an employment lawyer like myself or Zoya, of course, and then we can walk through the specific set of circumstances with you.
That's awesome. Zoya, did you want to add anything to that? And yeah, you can just keep yourself unmuted. There you go. Yeah.
All right. Assalamu alaikum, everyone. Apologies, I was having a few technical difficulties and Muniz is laughing at me because the tables have turned.
It's always me. I'm the one who's always like looking to, all you see is like my eye on Zoom. This is the first time everybody sees.
I was saying Dr. Azim, like, Muniz is not going to let me live this down, but here I am. So I think the only thing I would add to that is I think there was a question, it involved sort of the concern of human rights concerns. So the recent changes have made it so that employees do not, for COVID-19 circumstances, employees do not have to provide a medical note, but at the same time, the employer can make enough inquiry to understand what that medical accommodation what that need might be, and how to accommodate that. So I think communication is key in those circumstances, to try and get as much information as possible to help facilitate that, either that accommodation or that recall.
And you're never entitled to the diagnosis, but as Zoya mentioned, you can ask enough questions about the prognosis, so you can appropriately determine whether or not accommodation is even possible.
Excellent. Great.
Thank you so much for that, guys. That was really good. And you kind of answered my next question here, Muniza, but I'm going to ask it anyways. So this is pertaining to the employees. So some come back, others may not initially. If we reduce time/work or extend our time or our days, in event because of the time it takes for us to turn over the rooms or to help out with the backlog and whatnot, is that, and if our employees decide not to come back, is that considered constructive dismissal? The question here is that how do we implement these changes when it comes to these schedule changes? Do we have to put things in writing, or give them some time to consider these changes? In essence, are we obligated to give the same hours and the same pay when our employees return?
Okay, so fantastic question, and I'll answer the last part of it first, where you had said, if our employees don't come back, is that a constructive dismissal? If you are offering your employees meaningful employment and they are not returning to work, then the starting baseline will always be that they've abandoned their job, and you can then go ahead and terminate their employment. So, but moving back to if they refuse to return to work in the face of a reduction in hours, a reduction in pay, or an increase in hours, maybe they're having to work longer hours because of all the things that you mentioned, Hisham, including turnaround and cleanliness, or maybe it might just be, sort of adjusting to the new normal, so like a new practice, so to speak. Those are my kids in the background, I do apologize. Hopefully my husband will settle them down soon. But in those circumstances, if they say that, look, as far as I'm concerned, this is not the job that I signed up for. So you hired me to do X. I was to work 40 hours a week. I was to be paid $25 an hour. And now you're telling me that you're only calling me back 4 days a week and you're going to pay me $20 an hour. So anytime we are looking at a repudiation of one of the fundamental terms of someone's employment contract. I'm going to say that again in less legalese. So anytime we're looking to change one of the most important parts of someone's job, and the compensation, their hours, these are very important parts of their job. Technically, as an employer, you can be exposed to a claim for constructive dismissal. And a claim for constructive dismissal in layman's terms basically means that you haven't fired me, but you've changed enough things about my job that it's really not my job anymore. So I didn't sign up to be part-time. I signed up to be full-time. I didn't sign up to make $25 an hour. I signed up to make $20 an hour. I didn't sign up to work overtime now because of all these changes to the practice as a result of COVID. So in those circumstances, you would always be exposed to a claim for constructive dismissal. Now, with all of that being said, as employers, you are sort of, notwithstanding the fact that in doing so, it might be not above board from a legal perspective, you're in a decent place because a lot of employees, and remember our firm represents employers and employees, are receiving the legal advice, including some of the advice they've received from myself and Zoya, which is, notwithstanding the fact that it looks like a constructive dismissal, and it probably is a constructive dismissal, it may not be a bad idea to accept it, be a team player, weather the storm in hopes that at some point it will come to an end. Because if I'm working for Azim and I've only been there for, let's say, 2 years, and I was to argue because Azim reduced my hours that I've been constructively dismissed, I'm looking at about 2 months' pay in terms of severance. But from a practical standpoint, if I was logically to say, okay, look, Azim wants to reduce my hours. He sent me this letter that says that he thinks it'll be about 3 months, but he's not 100% sure, and he's hopeful that there'll be a turnaround. If I was to weather the storm, well, then I have gainful employment. So given the precarious job market that we find ourselves in, you are going to find that there are employees who are going to put up with some of these changes that are unlawful simply because they don't want to lose their job. Now, don't get me wrong. If if this is happening with respect to 5 or 10 employees, maybe even more, you may get a letter or two from a lawyer that says, look, there's nothing in the employment agreement that was signed by my client at the time that they were hired, which gives you the right, even in the face of a pandemic, to change their hours of work or change their compensation, and this is a constructive dismissal. In the face of a claim of constructive dismissal, you have 2 options. Either one, you can pony up some cash and sever the employee altogether and pay them. Or 2, what you can do is you can put them back to their status prior to that change being made. So you might turn around, Azim may turn around and say, well, Manissa's hardworking, she's loyal, she's fantastic, and it would have been really good for my financial health to put her in a part-time position, but I really don't want to lose her. So I think I'm going to bite the bullet and bring her back to where she used to be as far as hours and pay. Or Azim may turn around and say, well, you know what? As far as I'm concerned, there's no place for Manisa here. If she can't understand that we're suffering from a financial perspective, and I'm not just asking her to take a haircut, but I'm asking a number of other employees to take haircuts as well. And if she doesn't get that, she's only been here for 2 years. I'm just going to pay her out a severance package and call it a day.
And would this apply to those who have contracts or no contracts, like just a verbal contract as well?
Most employees actually still don't have contracts, and to be completely honest with you, those who do have contracts, most often than not, and certainly Zoya will attest to this, we can find loopholes such to render them not enforceable. So I like my contracts, the ones that I draft, and usually I'm able to find loopholes in all other ones. But I think the takeaway on this one is technically a reduction in hours, a reduction in pay, unless it's super nominal. And of course, you'll want to know what super nominal is, and we'll talk about that on a case-by-case basis. There's some cases in Ontario that say anything less than 10% or 15% will not trigger a constructive dismissal. But again, it's not trite law, so it's not an established principle. So technically, it is a constructive dismissal, but your chances right now are pretty high that your employees will accept that change. Now, I will inform you guys of another interesting little nugget. In the face of this pandemic, the provincial government is looking to make some changes to the Employment Standards Act such that a layoff or a reduction in hours or pay in the face of a pandemic like this would not be considered to be, would essentially could not be outlined as a constructive dismissal. There are some lawyers and some firms that are involved in these efforts, our firm included, with the provincial government, and some firms, some lawyers will be lobbying against those changes, but it's just something for you folks to think about in the event that you hear something come down the pipeline in the next few weeks.
Okay,
And
perfect.
thank you so much for that. And I just want to make it very clear, and on your advice here, is that do we, or should we, or do you advise us to put all these changes in writing, regardless if our employees do or don't have a active contract, a written contract?
Regardless of whether or not they have an employment agreement that they signed at the time of hire, anytime you're implementing changes, you should always put them in writing. Now, sorry, the one little nugget that I forgot to add there is if you have employees that are extremely short tenured, you can alleviate or insulate yourself from any risk as far as it relates to a constructive dismissal claim by just simply giving them notice. So let's assume for a moment that I've only been there for a year. Azim may turn around and say, I'm just going to give Maniza 1 month notice that in a month from now, her compensation is going down and her hours are going down. And that way you wouldn't even be able to argue that it's a constructive dismissal because I've been there for such a short period of time that you've given me the same amount of notice for the change as you would give me if you actually terminated my employment and had to give me a package.
Awesome. Thank you so much, Maniza. It did. Thank you.
Great. Okay, so let's get to the next question then. So can we create a transition period? So for those of us, as we know, we're probably going to have a reduction in income over the next, several months until we can get back to our regular productivity rate or seeing patients rate, I guess you could say. So let's say they're off the CEWS or off the Qs or off the CERB, the business is trying to recover. Can we put our staff on a reduced wage for a period of 6 months until we get our cash flow reserves up to our pre-COVID numbers? And I think that was, you pretty much answered that. The answer would be, yes, we could, and legislation hopefully is going to help us with that.
Yes, and I will let Zoya add to this if she wants, but again, the correspondence would look something like, in the face of COVID, we're dealing with, financial issues with respect to the business, and you may see some operational changes. For the time being, we have implemented a wage reduction and hour reduction over the next 6-month period in hopes that at the end of the 6-month period, we will be able to bring everyone back to where they were. I mean, we just heard on the news that the Bay had done something similar, and so all the businesses are doing it, but what you essentially want to do is you want to ensure that you are not committing yourself to a timeline that you may not be able to adhere to, because we're kind of in the wild west right now, and we really don't know what things are going to look like in 2 weeks, 3 months, or 6 months. So did you want to add anything on that?
I would just say that the CEWS is, the subsidy is for 75% of the wages, so that means 25%. There's still a reduction of 25% unless there's some sort of top up from the employer. So as Maniza mentioned, some of the case law does say, if there's a change beyond 15%, that could still be a constructive dismissal. If there's particularly, if right now there's no change with the government legislation, but if that comes down, then obviously that changes things. But for now, there's still that that risk that the CEWS only covers 75%, so 25% is still a reduction.
Yeah, and I think I've heard from different sources that we should be topping up if we can. Other sources are saying you don't need to top up because obviously we've had that reduction and over a 30% loss. So what is your take on that just particular situation as far as employers, dentists in particular, having to top up that 75%?
I think what it really boils down to is your ability to take the haircut, quite frankly, right? So, I mean, I know of certain dentists in your field who maybe from a financial perspective, it isn't the best decision for them to top up, but, demoralization is an issue for them at their practice. Keeping employees motivated, keeping employees productive is a huge issue. And, technically, you shouldn't have to feel forced to incentivize someone to do their job, especially in the face of a pandemic, but they're using the top up to incentivize their employees to do their job. So I think it really is a matter of a personal preference, unless of course there's something in an employment agreement or some contract that you have with your client, or with your employee, which I highly doubt, which would obligate you to do a top up. So did you want to add anything?
No, I think you covered it. I think that's pretty much it. It comes down to somewhat of a business decision. Can you afford to do that or not? Same with what Manisa was mentioning earlier. If you have these short-term employees, maybe you just give them notice. But if you have a longer-term employee, then maybe notice is more difficult to give in that sense.
Got it. Okay.
Can I just add a little bit of commentary there from a CRA and government perspective? So I think a lot of the rumors around topping up came really when Trudeau first announced the CEWS program, and he was quite forceful in his announcement, saying, you know, that they would expect that there was 100% top up on all the wages. And as we saw the program, you know, somewhat evolve, we kind of saw that kind of go away. So, you know, once the legislation was put in place, there's no requirement within the legislation to actually pay 100% of their prior wages. And the government has really softened their position on this. They have said that they may ask the question of employers of, you know, why didn't you pay 100%? But that there shouldn't be, we're not expecting to see any sort of, you know, penalties. We're not expecting to see any sort of repercussion on if employers don't pay the 100%. So that's been a clear like movement from the original announcement to kind of the present day what we're dealing with. And I would say most of the clients or people, you know, that I'm consulting with at this point are not paying the 100% for obvious reasons. I mean, the cash flow just isn't there.
And maybe just to pipe in with Melissa, so, you know, on the employment side, you know, qualifying and receiving the wage subsidy does not insulate you from a claim of constructive dismissal. So if you've got the wage subsidy, and you still have to do a wage reduction because you're not doing the top up, that doesn't mean that your employees can't sue you for constructive dismissal. It would just then fall into the category which I've spoken about, right? Which is they may be willing to bite the bullet and be a team player because they just want their job back, and in hopes that things will go back to normal for them at some point.
And would that be something we should get in writing as well, that they've consented to that wage reduction, that CEWS program or CEWS program?
I wouldn't say you have to get them to agree to anything on this.
Yes.
On the CEWS program, but on to Manisa's point, I think it's, you know, you would provide a letter as she was thinking of.
Hisham?
Perfect. So my next question here is that an employee was laid off, now refuses to come for work, and has gone on medical leave claiming mental health. What are my legal obligations?
Oh boy, that one keeps coming up over and over again. So again, so the starting point will be you're at the end of a recall period. You've told your employee that, look, there's a job for you to return to. They have an obligation to return. Your employee now responds by saying, I have mental health issues and I'm unwell. So what you have to do as an employer is separate that from the recall issue, separate that from the COVID issue, and just treat that as a regular ask for accommodation, which might be a bit difficult to do. So you're going to separate the COVID issue and then look independently at that specific employee. And if they're saying, remember, if they're saying that, you know, notwithstanding everything that you've done, I just don't feel safe coming into work, you don't need to accommodate anybody's fear, anxiety, or angst. But if they're saying I have mental health issues, which now render me, you know, unavailable to work for, you know, a period that's yet to be determined, a lot of employers, and interestingly enough, doctors as well, it's a little bit of a shot at you folks, you're under the impression that you, just because someone says I'm not well or I've gone to see a doctor, that you automatically have to take this hands-off approach and say, okay, well, then I have to give them a job protected leave, whether it's, you know, if they've got sick days or personal days, you may allow them to, you know, use some of those, and once those are depleted, then they could either be on an unpaid leave or they could apply for short-term disability. But if your employee is simply saying that I'm not well, I've got mental health issues, there is nothing that precludes you at law from asking the employee to cooperate in their own accommodation. Because that's precisely what they're asking for. They're not quitting, they're not resigning, they're not abandoning their job. What they're saying is, I can't come back right now because I am too sick. From a legal standpoint, you are not entitled at law to a diagnosis. However, you are entitled at law to the prognosis. So I can tell you at our firm, and I cooked mine up from scratch, I've put together like this 4-page questionnaire that I give to my employer clients when they are faced with a I'm too sick to come to work, for them to provide to the employee. And I will tell you, Oftentimes, doctors are completely comfortable writing a scribble on a prescription pad or a quick 2-liner that says, employee too sick to come to work, we'll reassess in 2 weeks. I've seen a number of those doctor's notes. And quite frankly, if I was to go see my doctor right now and say, I'm too stressed to go to work, can you put that in a note for me? 9 out of 10 times, the doctor would respond by agreeing to that. However, once the employee goes back a second time with a longer questionnaire that really forces the treating physician to put their mind to what an accommodation looks like and what that accommodation should be, where you outline what the job is, what the job functions are, what the hours are like, all of a sudden, some of these doctors become far more apprehensive to sign off on a document like that. So no, now it's not just about putting in 2 lines saying my patient is too sick. Now all of a sudden you've got this employer asking all these questions. And do I really want to, say that this employee is too unwell to work if I'm not entirely clear? So I find in round 2, you usually will get more substantive and comprehensive information as to how the medical condition, without being told what the diagnosis is, how the medical condition hinders the employee from being able to do their job. So send them a proper medical form, which asks appropriate questions from their treating physician, and then you can ascertain whether or not you have a legal obligation to accommodate their leave.
And what about pregnancy?
If they're lying, sorry, this is important. If they're lying, this is where they get caught.
So, okay, excellent. That actually leads me into the next question, because the next question would be, if staff are scared, in particular, let's say they're pregnant or they're about to go on mat leave, for example, they're worried about getting sick. I've always, I've listened to some webinars, and they always speak to the difference between a safety concern from a health standards aspect, or a difference between accommodation concern for our staff. So can you maybe speak to those 2 differences and our obligations as employers from, let's say, those staff may say, hey, it's unsafe, I feel unsafe, as opposed to they want to be accommodated?
So it's an objective standard, if I'm understanding the question properly. It's really an objective standard. So if you've got an employee who's pregnant and saying, look, I don't feel safe in the work environment, you always have an obligation. You as an employer have an obligation under the Occupational Health and Safety Act to create a work environment that's safe and healthy for all of your employees. You don't have to be perfect, but you have to be reasonable in doing so. So if you have a pregnant employee that says, I don't feel safe, and objectively there's no reason for that employee to feel unsafe, then you don't have to accommodate them. Now, that employee might be pregnant, but there might be something else with respect to their health that, might render them more compromised to be exposed to something in the workplace. In that case, you got to drill down a little bit and ask those questions before you make that determination. But if objectively everything in the workplace is safe and healthy, then employees have to come to work. And if they're saying that, notwithstanding the fact that you've taken all the appropriate measures and you meet that standard under OSHA, under the Occupational Health and Safety Act, here is why, in my unique set of circumstances, I still cannot come to work, then you need to look at that on a case-by-case basis. And in doing so, you'll do 2 things. You'll ask the employee their side of the story. You'll provide them with the medical documentation so you can get a better understanding of what the prognosis and the limitations are. And then you'll seek some legal advice on that as well. So do you want to add anything to that?
I think that's pretty much it, that you want to make sure that you find out what the restrictions are, because, for example, if it's not being in the same, not being in the same room as a patient, then maybe there's somewhere else in the clinic or the office that they can work. So I think once you get an idea of what the restrictions are, that might make it easier to figure out what work can and cannot be done.
Yeah, I think as dentists, we're all trying to get the proper PPE, and we're trying to do everything that we need to do to make sure that our staff are safe. I guess the main concern is, now it's time to recall, and now they come back and say, you know what, I still am worried I'm going to catch COVID. And so then recalling an employee.
Right.
Yeah. Sorry?
That's just, it's happening all the time, Azim. So
yeah,
exactly. And that little point right there is not a single media interview that I have done since all of this started, where that question does not raise itself over and over again. Yeah. You will have those employees, and I want to be sensitive. I'm going to call them problem employees, but I'm trying to be sensitive here, because not undermining the importance of COVID and the detrimental impacts obviously it could have on somebody's health. But you will always have those employees who will say, notwithstanding all of it, I just don't want to come to work until it's over. I want to continue to collect the CERB benefit. And I'm sure Melissa will touch on this at some point, but the CERB benefit is specifically for those who are involuntarily unemployed. And some people may not want to come back to work because they're like, I'd rather deplete that benefit and then come back to work. But if everything at work, and I'm never going to use the word perfect because that's not the standard that you will be held to from a legal standpoint, but if everything at work is reasonably well, they don't have the option of staying well, even though they might be really, really worried. You don't have a legal obligation to accommodate someone who's really, really worried.
Okay. I would just add to that both the employer and the employee have the option of contracting the Ministry of Labor and Occupational Health and Safety Inspector to come into the workplace and to assess whether it's actually safe or not. So sometimes employees think it's only for employees' benefit to be able to get a report, but at the same time, it could also help employers. Once you have a report that says this workplace is safe, there's nothing barring the employee from coming back in terms of the health and safety concerns then.
And that's a critical point, because these complaints to the Ministry of Labor can also be made anonymously, which obviously hold more value to the employees, and they're moving pretty quickly. They're sending these LRA officers very, very quickly to come do these site visits, which is good.
Yeah. Okay. Isham?
Thank you so much for that. That was a very good answer. Now, just to add to, or to get a little bit more clarification, Maniza, on the patient or the employee that we talked about for mental health. Dr. Soni here says, I've had doctors refuse to fill out the long-term form that you've talked about, but now what? If somebody's coming up and saying, well, I'm running into mental health issues, and then you give them this long form and you say, okay, well, I need your doctor to fill this out. And then all of a sudden they come back to you and say, well, my doctor doesn't want to fill this out.
Find another doctor. It's not your problem. That's the honest answer. The employee has an obligation to cooperate. This is an obligation that they have at law. They have an obligation to cooperate in their own accommodation. You are allowed to ask questions as to what the limitations are. Now, don't get me wrong. Like, a mental health issue could be something as simple as, and I'm very cognizant when I use this word, because there's nothing simple about depression, but maybe it could be that the person is suffering with severe anxiety and severe depression. Well, in that case, you got to be reasonable, because you don't need a 3-page form filled out for someone to tell you that the particular patient is depressed and anxious such that it renders them, incapable of working. So at some point, remember, the intention in giving them the longer medical note for their doctor to fill out, it's to really give yourself the comfort in knowing that you are dealing with somebody who requires an accommodation. It's not to be punitive or retaliatory or to punish the employee who's saying they're not well. So that's why you do need to look at things on a case-by-case basis. But for me, if there were issues around mental health and the person is not given it, like, they're not saying it's anxiety or they're not saying it's depression, because they're not legally obligated to tell me what it is, I would be hard-pressed, and maybe that's just me, I would be hard-pressed to say, well, I don't have faith that you're not being, I don't necessarily believe that you're telling the truth, and I think I'm entitled to know whether or not you require an accommodation. I'm not simply going to accept the fact that your doctor is saying that he or she doesn't want to fill out the form. In some cases, and it may not be forgive me, I've forgotten the doctor's name who's asking the question, it may not be in her case or his case, but in some cases, it might be appropriate to take a really hard-line position. And even from an employee morale perspective, you want to send employees the message that, yes, of course, you understand your obligations to accommodate somebody in the workplace, but again, you don't want anybody to take you for a ride.
Absolutely. Thank you so much for that. Sorry, go ahead, Zoya.
I was just going to add that I think it can be as simple as really trying to communicate and explain that the accommodation is a two-way street. That both the employer and the employee sort of have to work together to figure out, how can this be accommodated? How can we be flexible, or how can we help you in this process, right?
Awesome. And it's funny because this is where you get a little bit of a sense in our practicing style. So Zoya's like, sit down and communicate. No, just say, I think you're lying and I want a better medical note. So that's why it's good to have a collaborative approach. So, two different styles right here for you to win.
We love it. We love it. It's awesome.
Thank you so much, Maniza and Zoya. My next question Can one hire another employee instead of recalling a staff member who initially refused to come back to work due to safety but now wants to? What if that employee wants to come back at reduced hours instead of their usual full-time hours as requested? How do we best handle this situation?
You want to tackle that first, Zoya?
Sure. So, I mean, in terms of, again, if you're offering the employee their position, their full-time hours by, there's no reason for them to be saying no. That's not on you. If they're saying no, they're effectively declining coming back to their position and their job. So, I mean, you have fulfilled, the employer has fulfilled their obligations. Now, if they're asking for reduced hours, or if they're asking for certain shifts or whatever it might be, maybe a bit of an inquiry as to why, again, to make sure that there's no sort of accommodation or human rights issues. But at the same time, if you have that, you can, but you don't have an obligation to provide that to them.
As far as I'm concerned, if you, and in line with what Zoya said, but maybe just to add to it, if your employee initially declines to come back to work after a recall, my legal advice would be the employment relationship is over. And if that's it, they've resigned, they've abandoned their job, you've offered them gainful employment, which is your obligation to do so. They said they're not coming back, and that's the end of it. Now, if in the interim, now let's just assume in some, unique set of circumstances, it's somebody you really like. And the person says, I don't want to come back now, but I'd like to maybe consider coming back a little bit later. So maybe when you do your next round of recalls, try me then. And it's happened, and you've hired someone else that you like and you don't want to terminate that person. Then at that point, if you don't want to recall the employee who didn't want to return to work the first time, you always have the you always have the option of simply severing their employment at that time and paying them out. And the one piece of advice I will give you to give to every single professional that is on this webinar is these employment agreements are so unbelievably critical, because if you have someone who's working for you, let's assume someone's been working for you for 8 years. If you have them sign off on an employment agreement, and this will make all the difference in the world in terms of strategy when you want to sever somebody and how you want to sever someone. So if you have someone who's been working with you for 8 years, they've signed off on an employment agreement that limits them to employment standards, then at the time of termination, all you're entitled to give them at law is 8 weeks of pay in addition to benefit continuation. If that same employee who's been there for 8 years has not signed an employment agreement, then you could be on the hook for 8 months of severance. That's an astronomical difference. So to go back to that example that you've just outlined, Hisham, I might turn around, and if I've got an employee who signed off on an employment agreement and I only owe them 8 weeks of pay, I might turn around and say, well, I don't want to bring Azim back because I've got Zoya now and she's pretty awesome. And, Azim's only been there, I have this limitation of the ESA. I'll bite the bullet and pay Azim 8 weeks. But let's say Azim has not signed off on the employment agreement and I want to keep Zoya. But now I'm like, well, I can't afford to pay Azim 8 months. So now I'm going to get rid of Zoya because she's cheaper. She's only been there for a few months. I don't owe her much. And I'll bring back Azim. So these employment agreements are so unbelievably critical. And trust me, when you fire people, it will really affect your strategy in terms of who goes and how much notice you give them. It makes a world of difference.
I just want to know, why is Azim always the bad guy? No, I'm just kidding.
I don't know. I've just decided, Azim. I'm sorry.
Thank you, Muniza.
So moving on to our next, that was great. That was excellent. Thank you, guys. So a question leading into that actually was, how can we adjust our contracts to account for situations that involve temporary layoffs in the future? I know many have a temporary layoff clause, whether we can put in a wage reduction, because as you mentioned, the 1 week per year of service for the max of 8 weeks, as opposed to now the 2-1. And I think the consideration here is more for that second wave that might come. Yes. The worry about that.
So for the second wave, and I mean, it's definitely a viable concern. So your employment, just make sure you have an airtight provision in your employment agreements that clearly outlines that, you know, you have the right to lay off. So you don't have an employee taking the position that it's some unilateral thing that you've done. The employment agreement speaks to it. I will say, notwithstanding the fact that employers often try to put in provisions that say, you know, the employer has the right with notice to change your job duties from time to time, to adjust your hours, to adjust comp. More often than not, I find that those provisions don't really mean anything. And it's really just, is it a constructive dismissal or is it not a constructive dismissal? So you could have that, so the layoff language should be there and it will insulate you from a claim. If you lay somebody off and they say, look, I understand the ESA gives you the right to lay me off, but from a common law perspective, you can't. So that part will be dealt with. But, you know, notwithstanding language around pay reduction hours, I find that language doesn't really go anywhere. Now, with all of that being said, however, I think this is an area of the law where even as employment lawyers, we can expect a lot of change because of what's happened with COVID. So the legal advice that I'm giving you now on this issue may become obsolete a year and a half from now, because I know there's going to be a lot of litigation that comes out of this time period. And even myself as a lawyer, and this is not particularly helpful response to you, but it's honest, I think this area of the law is going to evolve. So I would say if you're having employees come back, two things: have them sign off on an employment agreement. Keep in mind, if they're existing employees, in order for them to sign off on an employment agreement, you have to give them something new. That might mean benefits if they don't have them, increased vacation days, maybe you give them a signing bonus. In order for that agreement to be valid and to be enforceable, they need to sign off on it with something new. And then you can put in a provision that will say, in the face of a pandemic, you understand that your employer has the right to reduce your compensation, to change your hours. And even though today I am telling you that would expose you to a constructive dismissal, I don't know what the law in this area is going to be in the next few months. And I expect litigation in this area to be quite interesting. And that provision might be 100% enforceable a few months from now.
But how would employees feel during the pandemic to get, hey, here you go, here's a contract? Like, how is that going to go off?
Not good.
Not good.
You're right. It's a fair point. I mean, who wants to come back to, maybe a reduced hours or reduced comp? And at that point, you can blame the big, bad, scary lawyers and say, well, it's Zoya and Meniza, we sought some legal advice from them. They swept in and suggested that we make operational changes. And now we want everyone to sign off on an employment agreement. Maybe, Zoya is a fantastic employee. And in her case, she says, I'm not signing it. And you're like, darn it, I tried. I'm still going to bring Zoya back. And you may have to do that with some of your employees. But trust me, especially for you dentists and for you surgeons who have long tenured employees, this is your chance to get them to sign an employment agreement and really save yourself a lot of money if you have to terminate them in the future.
Right. And I think Meniza kind of touched on this, but the employee doesn't have an obligation they don't have to sign those contracts. So if they really feel like, well, all of a sudden now you're putting a contract to me that is now limiting my entitlements upon termination, even though you're giving me something in exchange, I don't want to sign it. Then I don't
want something in exchange. I don't want your extra week of vacation. I don't want the $500 or $1,000 signing bonus. And that doesn't mean you can fire them. So Zoya's right. You bring them right back to work, but it's definitely worth a try.
Okay, so we're going to get Zoya to implement the contracts, and then if they breach them, we're going to get Meniza on them, right? That's got it.
They make a good team.
Yeah.
Awesome. Thank you guys so much for that. The next question is that we are nearing the statutory 13-week layoff period. And Meniza, you did say that there is a possibility of it being extended down the road, but not currently. What is the best advice on what to do if we are still unable to see patients and get back to work? How do we extend this period or mitigate our risk? And is there any hard stops to what this period can be extended to? And I would love to have Melissa chime in on this as well, if she can also offer some creative ways for us to go ahead and extend this period and reduce our risk as employers.
So I'll give the short answer in that and then turn it over to Melissa. And that it's a very simple formula. So if the only way for you to extend that layoff period beyond the 13 weeks is if you have benefits. And if you have benefits, you can give benefit continuation and extend it all the way to 35 weeks. But if you get to the end of the 13-week period, there's no benefits and no ability to extend it, and you're not ready to call people back, Hisham, and you're not ready to give them their job back, you have to fire them and give them severance pay.
Benefits meaning?
Benefits meaning health and dental benefits. So if they had those benefits and you're willing to continue them, you can lay them off for a period of up to 35 weeks. If you don't have benefits, it's that maximum shorter period that Hisham had referenced. And if you reach the end of that period, and you don't have gainful employment, then under the Employment Standards Act, you have a legal obligation to pay them out and give them severance, and the job is over.
Now, Moniz, I'm sure 150 dentists just thought about, well, we do offer them dental benefits. So how do we maneuver around that?
So it's essentially a formal medical plan, right? So if they've got dental benefits, if they've got general medical benefits, if it's just dental because it's something you're able to offer them on an in-house basis, that wouldn't qualify as benefits under the Employment Standards Act. These are actual, like a benefit contribution plan that you pay into on their behalf. And so if you're going to continue those, you can max yourself all the way up to a 35-week period. And if you haven't done that from the onset, then if you come to the end of that shorter period and there isn't a job for them, you got to pay them out their severance.
And then sorry, go ahead.
And just to be clear, so the point of those periods is after the 13-week period, it's a deemed termination. And after the 35-week period, it's a deemed termination. That's the significance of the 13 and 35 weeks.
And now I have a couple of questions that people are asking the same thing. What if we go ahead and implement, for example, a benefit plan closer towards the 13-week mark? Will that be able to go ahead and extend that for us to an additional 35 weeks?
I would say no. I would say in those circumstances, if you've only implemented a benefit plan, so you can have the benefit of extending them to 35 weeks. Look, you might have an employee who will bite. Okay, so let me put it this way. From a legal standpoint, no, that doesn't qualify. Does that mean that you won't get all of your employees saying, I'll take this. I've got benefits now. They've extended me to another 35 weeks. I still have the benefit of being able to apply for EI. I'm going to accept this, even though, Maniza and Zoya, I called their office. They said it's wrong. I'm going to accept it anyways, because there's a chance that I'll have a job at the end of this. So again, it's one of those things where from an employer perspective, you do have the benefit of doing some things that you may not be able that you may not have been able to get away with in any other sort of work environment. So you can give it a try. Is it legally untoward? Yes. Will it work? Maybe, because guess what? People want to hold on to their jobs.
And Melissa, did you want to add to that? Because I know some people were talking about adding, maybe potentially using the CEWS program or CEWS program to maybe top up their staff, to be able to take advantage of this CEWS and also not trigger that termination. So any thoughts about that?
Yeah, I mean, from a pure, based on the subsidies, you definitely could top up and pay the additional like $250 per week or up to $1,000 per month, be eligible for the CEWS, and the employee can still get the CERB. But I would kind of put it back to a legal question, like, are you offering meaningful employment at that point? And, I can't answer that. I would kind of push it back to the other ladies on that question. But from a pure subsidy perspective, you definitely could do that and have the wage be eligible for the CEWS and have that employee be on CERB. So I don't know if you guys can answer if that would be considered meaningful or not.
Well, I mean, and so it's a very interesting point that Melissa raises, where you'll see examples over and over again from an employment perspective where technically things can be done. Well, technically you can do this, so they qualify for this. I mean, for God's sake, under the Employment Standards Act, there's legislation in this province that gives you the right to lay off, and you still have employment lawyers telling you that it's unlawful and it's illegal. So how do you sort of wrap your head around that? So again, while you may be able to qualify for something technically, would that still expose you to a constructive dismissal claim? Probably. In these circumstances, even if you put everything in place to offer the benefit continuation, if it wasn't in place at the time when they were recalled initially, then the employee might turn around and say, this renders my layoff altogether, or the extension of my layoff a recall. I'm at the end of the 13-week period and you have to pay me out now.
Got it. Okay. So that actually leads in really nicely to our next question. So once you do put them on the wage subsidy program, and as we all know, that started on the next period, or the previous period, was May 10th to June 6th. And now that's just been extended till August 29th. After this period, does it reset the 13-week layoff period? And we do know generally that layoff period is within a period of 20 weeks, right? Yeah. So if we put them on the CEWS program and now that's been extended, does that basically reset the clock, or are we just kind of buying ourselves whatever extension that we just put them on?
So do you want to start with that one?
Yeah, sure. So again, you did mention, so it's 13 weeks is out of the 20-week period. So if you did bring them back for a significant amount of time, then it would, as long as you're passed within that 20 weeks. And so you basically have to have 13 weeks within that 20-week period. So if it's, if you're beyond the 20 weeks, then it will reset the clock. But if not, then it's within the same time period.
Got it. Okay. So in essence, we would have to rehire them back for like 2 months and a week in order to reset that period. Otherwise, we're just buying ourselves that amount of months that we put them on the CEWS program.
Right.
Got it. Okay. And anything you wanted to add there, Melissa, as far as?
No, I think that's more of a legal question.
Okay.
All righty, perfect. So we're going to transition now to have have Melissa answer some questions that have more or less, they're more accounting heavy. I believe that Muniza, you have to run in a couple of minutes. Is that correct?
Yes. I will listen for the next couple of minutes and then I will quietly bow out. I'll only say that, again, we're happy to chat with you folks. You can pull our profiles online, email us, give us a call, and if you have individual questions. And I can see the chat board lighting up, and I know there's so much of what we say that is applicable, but then there's so much that falls within the cracks, because I know every individual case is a little different. So always happy, shoot us an email, give us a call. Zoya and I would be happy to answer any of your questions. And Zoya will stay on with Melissa if there's any overlapping legal questions. And I'm going to stay on and listen in to Melissa as well.
Thank you so much for that, Muniza. And just for those who are watching the chat lines right now, I did post Muniza, Zoya, and Melissa's email addresses as well. So once again, with Muniza and Zoya, they have graciously offered us a 15-minute free consultation. So please take advantage of it whenever you have the opportunity. And once again, Muniza, thank you so much for your time. So we're going to go ahead and transition to Melissa now. It's your time. My first question for you is, has everyone that was on EI transferred over to CERB? If so, will the government adjust the payouts accordingly?
Yeah, so the short answer is no. But the long answer is, if you were on EI or you applied to the EI program prior to March 15th, you will still continue under the EI program, under whatever was approved prior to the pandemic. If you applied, however, to EI after March 15th, then you are automatically put into the CERB or CURB program, however you want to pronounce the acronym. So to give you kind of an actual numbers example, if you applied before March 15th and you were eligible for, let's say, $300 for 12 weeks, then that's what you'll receive, and you won't be placed in the CERB program. However, in that same scenario, if you apply kind of after March 15th, you will receive first 16 weeks of CERB at $500. And then after that 16 weeks, you will then receive your $300 for the next 12 weeks. So there's a clear distinction, and the timing around when the application came in is really what's key in this. There's a lot of confusion around the EI, like what's EI, what's CURB right now, and which program are people in. I think for the most part, the perception is that everyone is in CURB, but that's really only the case if you applied after that point. So if, for someone who was on it previously, they're still continuing in the EI program. And the reason why they really kind of changed it to be a whole new program was really around the EI program can only fund so much. So they needed a different way to be able to fund kind of the pandemic issues. And that was, why it's become a whole new program and caused some confusion, I would say, in the market in general. So yeah, it's really around that timing, and it's really at that March 15th. So for the most part, I think that the employees that we would be looking at on this call would all be after that March 15th date. So they would all be under the CURB program.
And then
we'd be dealing. Yeah.
Go ahead. Sorry, Melissa. I didn't mean to interrupt.
Yeah. So then we'd be looking at, if they're still, at 16 weeks after CURB, then we have to see, does CURB get extended, or do they then apply for regular EI, which if CURB doesn't get extended, they would then apply for regular EI at that point.
You got it. And then I think that's one of the most common questions is, well, what happens, for example, if I want to, or if I may not have a job after all this is done, is all of the EI funds that I've had or that I've paid into, do I still qualify for that after CERB is completed? And your answer is yes. Is that correct?
Yes. So I would say there hasn't been, you know, a mechanism for how it's all going to tie together once this is over. Everything's changing so quickly, obviously, with all these government programs. But if someone is, you know, laid off or fired after this point, then after the 16 weeks, then they would then just fall back into the normal EI and apply that way. We're not sure at this point, and I don't think it's come out if, you know, there'll be an automatic transition if they're still without work, or how that, you know, if you'll have to apply again. The programs are actually very separate in how you apply. You know, one is very specifically through the EI program and one is very specifically through CERB. So it will likely be that you need to reapply for EI once CERB is over.
Awesome. Thank you for that.
Yeah, it's interesting because my hygienist kind of had reported that she was getting EI and then they retroactively went back and changed it to CERB. And then she got that. Normally there's a 1 week period where you don't get paid for EI. They retroactively got paid for that. And I guess she's just waiting for things to get figured out. But to that point, if you have somebody who's going on that leave when they get back, I guess their concern is, you know, are they still going to have EI to be able to manage theirs? And the answer from what I'm hearing is yes, as long as they applied for CERB after March 15th.
Right. So if let's say in the case they were on, you know, they're on CERB now in that case, and that was as of March 15th. So they're, you know, normally on CERB, they've never been on actual EI. But by the time they come back, they will be going on maternity leave. There are 3 sections, I'll say, of the EI program. One is under regular benefits, so like losing your job. One would be under like sickness, and one would be on paternity leaves. So the maternity section of EI is still just normal. So nothing has changed from a maternity side of things. So in her case, you know, she would still be getting the CERB, assuming for the, you know, the 16 weeks that she's off, unless the employer brought her back, you know, before, you know, let's say in the next month. And then when she goes to go on maternity leave, she will apply for the normal EI for maternity leave versus being on the CERB. So
now what about vice versa? What about vice versa if they're coming off of a mat leave? Because we had a few people ask that question. They're on a mat leave currently right now, and now they're going to be coming back to work.
Yeah. So if they're on a mat leave and they're currently, so they should be receiving EI, not CERB, in that case. So then if their mat leave runs out and they stop receiving EI and they're still without work because of COVID, then they could go on the CERB at that point. If however their employment is back in place and they can, you know, start working, then obviously they wouldn't be on either. But if they cannot start working again once their mat leave is up, then they would go on CERB.
Excellent. Thank you.
Awesome. Thank you so much. Melissa, my next question is a little bit of a meaty one. It's a CEWS program question. Can you give us general comments on how to use it properly? 75% of wage up to a maximum of $8.47 per week. Do employees have to actually be working, or can we just pay 75% giving a large reduction in income? What will be the test to see if one qualifies? And the second part of this question is how the temporary wage subsidy program integrates with the CEWS program. So I'm just wondering if you can elaborate on that.
Yeah, that is a meaty question for sure. You know, sometimes I spend 30 minutes on that question by itself, so I'll try to condense it down a bit. But so there is obviously a very specific calculation that must be completed for every employee. You know, the CRA has put out worksheets and spreadsheets for every employer to help calculate what will qualify for their employees. The kind of general big picture view and what everyone always talks about is that the wage subsidy is 75% of the current wages paid up to the maximum of $8.47 per week per employee. This is somewhat, you know, misleading in a sense, and I'll run through a little bit of an example to show you how it can, you know, it cannot be 75%, it can be higher and it can be lower depending on, you know, where each employee sits. And then to answer the question of, you know, we kind of touched on this before with Muniza and Zoya, you don't have to pay 100% of their prior wages. The government has asked employers to try and do so. However, there is no requirement. There's nothing in the legislation that says it's a must or that it's a requirement of, applying for the CEWS. The calculation is based on what the terminology is called baseline remuneration. So the baseline remuneration is essentially the average wage that was paid to each employee from January 1 to March 15th. And I'm going to emphasize the word paid here. So this is actually what was paid, not what was earned by those employees in that time frame. And that is a really key distinction for the program, because there are different variations of the calculation. You can get to a very different number if you use what was earned versus what was paid. So I'm just going to emphasize again, the baseline or the average amount is what was paid in between January 1 and March 15th. So you may actually have someone that got a paycheck on January 2nd that was for work done in December, and you're going to include that in the baseline. So a simple example to kind of go along the lines of, why it's not always 75% would be if someone's baseline amount was $2,000 a week. So the employee was getting paid $2,000 a week on average from January 1 to March 15th. Now you bring them back and you're paying them currently $800 a week. So when you work through the actual mechanics of the calculation, the employer would actually receive the full $800 subsidy on this employer. And that's just purely because the baseline was so much higher. So you're allowed to receive the full amount just based on the calculation. So in this case, you're actually receiving 100% of their wage, not 75% of their wage. So this is a clear distinction, and it can go the opposite way as well, right? So, if you have someone that had a low baseline, so a low average from January to March 15th, and now you're paying them more, maybe demand is up and you have to pay them more, they have to work more hours, you're actually going to get less than what you're currently paying. You won't get the 75%, you'll get less. So the 75% is what everyone terms it out there, and everyone's talking about, oh, you can get up to 75%, and I have clients call all the time and, okay, I qualify, so I can just take 75% times this, and it's like, no, like it's actually very complex for each employee, and you do need to go through and do the calculation. If you continued in that example, if you did continue to pay them the $2,000 a week, so, if things are allowed to be open again and you bring them back at their $2,000 a week, because that's the demand, then you would receive the maximum $847 subsidy in that case. So just a couple small examples to illustrate kind of the 75% and why that's somewhat misleading. But, the calculations are really based on 75%, but it really depends on what you do with your employees. So employees do not have to be working. That was, I think, another piece of your question. They can actually be paid while they're on leave. So for the, most of the employees that you have right now are likely on leave. They're likely not getting paid, which is, all the questions around layoffs and, what we have to do. If you decide to bring them back, so, whether you're open or not, if you decide to bring them back, then those employees that you're paying, so if we go back to the first example, you're paying them $800 now, you're going to get $800 subsidy for their wage, so fully subsidized. You also can get a refund of the employer paid EI and CPP on their wages. So, on back of the hand calculation, if that works out to $70 a week that your employer paid EI and CPP, you also can get that back on top of the $800 that we already talked about. But this is only for the case that where employees are not working at all, but they're being paid. And there isn't a requirement that says that they have to be paid 100%. It's just that they're being paid. So in the case that I gave where, their 100% would be $2,000 and now we're paying them $800, they're being paid so you can get back their EI and CPP if they're on leave. And then lastly to that is how does the CEWS integrate with the temporary wage subsidy. So the temporary wage subsidy was the first subsidy that came out, back in early March. It feels like so long ago now. And this was 10% of remuneration paid. And, basically from there, when Trudeau announced it, there was a lot of comments around, this is not enough to help us keep our employees, this is not lucrative enough, like we need more help than this. And that's what stemmed, the CEWS program was from all of those comments. So that was really just temporary in nature to just help people by saying, we are trying to come up with a program. So that is only 3 periods, and it will end after the 3rd period, which is in June. And the way that this integrates is that if your company is eligible, which most companies would be eligible, so any company that is a Canadian-controlled private company and was eligible for the small business deduction would be eligible for the temporary wage subsidy and had a payroll account as of March 18th. You must actually calculate the temporary wage subsidy. It's not an option. You have to take it, and it then corresponds to the CEWS. When you go and apply, you take off. So let's say your CEWS, in the case that I gave, your total CEWS application is $800. You're going to get back $800, and your temporary wage subsidy would have been $80. So when you apply for your CEWS, you're going to get $800 less $80. So you're going to get $720 with the CEWS application. The temporary wage subsidy, there's no official application. It all comes out through your payroll remittances. So when you go ahead and do your first payroll remittance, whether that be June 15th, you're going to take a direct reduction against the income taxes withheld from your employees. So in my example there, you're going to take $80 off that you do not have to remit to the government. Now, if by chance you don't know that you have to do this, or you forget, or you don't calculate it, it's okay. You can reduce it from future periods, future payroll remittance periods. Or if you don't take it at all, it still will actually come off as a credit when you file your T4 summaries for the year. So all in all, that means that you can't get away from it. I've heard lots of people advising, like, just forego the temporary wage subsidy, just worry about the CEWS subsidy, but you can't do that if you actually qualify for it.
Now, for your clients, that's what you're pretty much doing right now. You guys are figuring out those, depending on which employees have extended that period, or sorry, have taken advantage of the program.
Right. So, if I get a lot of questions about, people are figuring out their calculations, and people are, sending me their spreadsheets and stuff. And one of the first questions is, have you taken a reduction in the temporary wage subsidy? And if not, we need to actually work through that calculation too, because they have to go hand in hand, and you have to take the reduction in the appropriate period on CEWS.
Got it. Okay. Perfect. Excellent. That's my question now. Okay. So the calculation basically is for that CEWS calculation, number one, well, this was about the calculation, but basically get an accountant, consult with your okay. But it was just saying, the question was, do I take the total remuneration and divide it by 10.7 weeks to get the average? And then will that be used to determine the average weekly salary? What about salaried employments, and if they got a raise in that period, let's say February 10th, or are we just pretty much taking the average from January 1st to March 15th? Because for most of us, let's say our payroll may have started on January 6th, right? So yeah, how does that work exactly?
Yeah, so you're going to basically take their year-to-date earnings, their year-to-date what was paid, from January 1 to March 15th. So if their first payment, their actual payment date, so not pay period ending, but the actual payment date was January 6th, that would be the first one you would take. And then you would take whatever the last one was, either on or before March 15th, add all of that up together, and then divide by the number of weeks that's actually included in there. So if January 6th has a payment period for the last week of December as well, you might be including like 11 weeks or 12 weeks, depending on if you're biweekly or weekly. So you're going to take like a true average of whatever the year-to-date amount is as of March 15th. So it doesn't have to, the 10.7 isn't a hard and fast number. It's going to be whatever the actual number of weeks was that you're including in that number.
Got it.
And you will also include, if the employees happen to receive a bonus in that time, or commissions, not really in your cases, but you would include kind of other payments like that that were paid. You wouldn't include any dividends for shareholders or anything. But yeah, and to the question of what if they got a raise, that would just all be in that year-to-date earnings, and it would all average out. So you would still just take that average. And again, I want to emphasize, you know, this is based on what was paid, not what was earned.
Okay, excellent. Michelle?
So the next question that I have is, a dentist is on payroll and was told to apply for CEWS after June 6th versus their wife who gets dividends and is on CERB. Is the dentist at a higher risk of an audit going on CEWS? When do I get the payments back, in brackets? No one I know has received payments from remittances. If I already took out payroll, can I get back and revert? Can I go back and reverse, then apply for CERB?
Yeah, so, you know, I don't think there's any higher risk of an audit at all. And I'll explain a little bit of what we know of the audit process. And I put audit in kind of air quotes because it's not actually as intense as we, you know, would have maybe anticipated. So there's no higher risk of a shareholder claiming any CEWS subsidy there. So as a shareholder, you are eligible for CEWS. It's set in, you know, right in the calculation exactly how a shareholder can get CEWS, assuming that that shareholder was always on payroll. So, and this is a really key distinction and really important because, you know, we do have sometimes shareholders not taking regular payroll. They might take, you know, one lump sum in December where we declare a bonus, or, you know, maybe they're only on dividends, or maybe every other year they're only on salary to like offset installments. Lots of reasons why people would do things different. The key to take away is that for the shareholder to be eligible, they had to have received payroll in between January 1 and March 15th. And the reason being for this is that when you actually go through and do the calculation for them, no shareholder can receive anything more than 75% of that baseline or that average. Well, if they didn't receive any payroll from January 1 to March 15th, their baseline would be 0, and thus the calculation would be 0. So as for, you know, can you go back and change what you've done? I would say no. They've made it very clear that if they see anything that you've manipulated or done what is not considered normal in your case, you know, they will apply the penalties. There is actually a provision in the legislation that even allows them to name the companies that have applied. And, you know, this can be used for good purposes, I think, and it also can be used for bad purposes if you're manipulating things. So, you know, they could come out and say, look at all these companies that we helped, you know, we supplied all wage subsidies, here's all the names of every company in Canada. And then they could also say, you know, here's a list of everyone that tried to manipulate it that we actually applied penalties to. So you want to be very careful that you're not really changing anything that is out of the norm. You want to keep things the way that they are, and you don't want to go back and try and backdate anything or do anything that would be seen as manipulating the program. As for, you know, could the husband get the CEWS and the wife has dividends and is on CERB? That's definitely fine, assuming that both meet the proper qualifications. So if the husband was on payroll from January 1 to March 15th, they could clearly, you know, get the CEWS. And if the wife historically has received dividends, you know, at least 5,000 in 2019, which is the condition for CERB, and non-eligible dividends at that, then, you know, she should be eligible for CERB, assuming that the business is still shut down. If she has the ability to come back to work, then there would be, I think, some gray area there, because it does require you to actually be shut down and unable to work on the CERB. So, and then the payments, we actually have been in contact with a few of our clients that, you know, submitted applications recently, and they are receiving payments. So I would say on and about Monday is when the payments started kind of being pushed out. It generally takes about 7 to 10 days to receive the payment after you apply.
Excellent. Thank you. That was great. So this actually, would want to bring maybe Zoya into this question as well once you answer, but can we retroactively, so now obviously we're all kind of scared of this 13-week layoff period, right? We're all just kind of freaking out. So can we retroactively go back and apply for the CEWS program in order to extend that layoff period? And we know that the CEWS has been extended till August 29th, but let's say, for example, we're not sure how long this is going to last. Can we take advantage of that full program and go right back and say, hey, let's put them all back on, yeah. And then if we do that, I'm assuming that the staff would then have to pay back their EI and CERB. I guess the account, from the accounting standpoint and then from the legal standpoint would be great.
Yeah, so from the actual program perspective, you have kind of two options for today. One, you can decide to hire employees back on a future basis. So, you could hire them back as of Monday, you meet the conditions of the CEWS program and their wages would be eligible. You go and calculate, each person's eligibility, and that's no problem. There also is the ability to retroactively hire staff back under this program. And the only condition that they've really set in this is that before you actually apply for the CEWS, go online and put your application in, you must actually pay for all of those back wages. So how that would kind of logistically work is if today I said, okay, I'm gonna retroactively hire Zoya now back to March 15th, I would need to go and calculate whatever her retroactive pay would be. It doesn't have to be at 100%. So it could be in my, initial example where I said, normally she makes $2,000 a week. I'm going to retroactively hire her at $800 a week. So I go and pay her $800 a week now back to March 15. I physically give her a check for that. And then I can go apply for the CEWS for those wages. You have to do that. That's the only condition they've really put in place for the retroactive hire. In that case, if Zoya had already received the CERB for 2 periods at this point, she would be required to go and pay it back. If I paid her more than $1,000 a month, she would be required to actually go send the check back to the government. There's a whole specific process on the CRA's website where you have to mail it in, what you have to note on the check. There's a process there to do that. She would have to do that. The one thing that I think is key in this is that the government has said that in their kind of phone talks with the leaders in Canada, they've said that it won't be on the employer to ensure that the employee has paid this back. So this is clearly an employee responsibility to pay that back. When they go online and they submit their claim for the CERB, they are attesting at that point that they have not been paid for those months or for those weeks. If that is no longer true, it's then their requirement to repay that back and to offset the statement that they have made. The employer's obligation is with the CEWS program, not with the CERB program.
Got it. Okay, that makes sense. Yep. And Zoya, can you maybe add from an employment standpoint, as an employer worried about this layoff period, are you seeing people do that to help kind of extend their layoff period?
Sure, yes, absolutely. So once the employer has actually qualified for this use, I think one of the issues in the beginning was whether the employer would qualify or not qualify. So a lot of employers were sort of in that waiting period to figure that out. And so once that's been approved, then yes, that is really helpful to bring the employees back. Then what is the, we've talked a lot about the constructive dismissal claim, and that's sort of what the worry is with the layoff period. And so what really, if the employee is being paid and they're getting their wages for that time, then that's less of a worry. Now you don't have to worry about the constructive dismissal.
Got it. And is this what you're seeing, Melissa, for let's say the dental community in particular? I'm not sure. I know you guys have a lot of clients who are dentists, but are you finding that's what many dentists are doing? In fact, either retroactively going back or now taking advantage of the program, given we're getting close to that period. And now, of course, we know they've extended it too.
Mm-hmm. Yeah, I would say actually most of the dentists that I've been talking to are somewhat hesitant to apply. So most, I would say, are probably they're in a waiting period right now where they're trying to figure out, what do I do? Do I retroactively hire them? Do I hire them going forward? They have all these legal questions that we talked about today. But that question needs to be answered, pretty shortly on if they're going to retroactively hire or not. if they can make a case for, you know, in the example I gave, you know, they were making 2,000 and they're now making 800. You know, is that the right number? I don't know. Like, that's more of a business decision, what you're going to pay them for. But from a retroactive perspective, if you can get all that money back through the subsidy, there's relatively low risk from a cash flow perspective. So, you know, that probably makes some sense to do, especially if we're trying to avoid, you know, the 13-week period and everything. But I think you still need to consider some of those other legal questions we talked about as to, you know, what is enough to not get you like legally in trouble with your employees.
Awesome, thank you for that, Melissa and Zoya. The next question is a CERB related question, and they ask, if everyone is on CERB, can we pay the additional $250 per week in brackets to keep them under the $1,000 threshold so they can still qualify for CERB and get reimbursed through CEWS, and they will get ultimately $750. Example, is the employee coming in for one day for an admin work at, let's just say, $30 an hour for 8 weeks?
Yeah. Yeah, I mean, technically in the program, you can do that. And I think, you know, we briefly did talk about that earlier with the questions that we had. So technically, if you paid them the $250 per week, you could, you know, you'd probably get that fully reimbursed under CEWS. They could still receive the CERB, given that they're, you know, they have less than $1,000 of income. So, you know, you've upped them, they're probably receiving $3,000 a month. There's nothing that says you can't do that, for sure. I would still kind of come back to like the legal question of, you know, can they come back and, you know, legally come down on you? Again, you kind of go back to the point of, you know, you're clearly trying to help them get the maximum amount that they can get when you're not open. So hopefully they're willing to work with you. But yeah, from a pure like subsidy program perspective, you can definitely do that.
Excellent. That's great. So the next question is, and we're getting pretty close to finishing up here. If you're completely closed, which most of us are, I know some of the offices are still seeing emergencies, what would you advise is the best case scenario in order to maximize our pay to our staff? Because of course we want to help our staff as close to their pre-COVID amount, but still maximize our government benefits and not put ourselves at a higher risk of audit, for example.
Yeah, like I would actually go through and do the calculation. You know, you have all the data for the baseline calculation for all your employees. You can go through, calculate everyone's baseline, and start looking at the numbers to see, you know, if I brought someone back at 70%, how much would I be subsidized for? If I brought someone back at 80% or 50%, you know, you can start looking at the numbers and say, what can I reasonably do? And keep in mind that you will have to front that cash today because you won't get your subsidy money immediately. It's 7 to 10 days, so it's not that long, but you do have to actually be able to have the cash to pay your employees. So I would probably start looking at the numbers if it were me and see, you know, should I go back? If I went back and retroactively hired everyone at 50%, who would be better off? Who would be in a worse position? You know, maybe some people were actually making less than the CERB, so maybe those people don't, you know, that doesn't make sense for them. So I think it's probably, you know, each employer looking at, you know, almost each employee to see, or at least each employee category, you know, if you have people in similar situations, to see what, you know, what benefit you can get, and also, is that going to be a detriment to that employee, or is it going to actually help them get more? But I think without, you know, actually looking at the numbers, putting it in the spreadsheet, it's going to be very hard to, you know, figure out what that number is without, you know, estimating it without actually doing that calculation.
Makes sense.
Thank you, Melissa. This is my last question for the day, and then Azim will be asking one more. Would offices that used a cost-sharing program qualify for CEWS?
Yeah, so this has been a question that's come up quite a bit in, you know, in the professionals community. It's not that common in other industries. So, you know, where you have a cost-sharing entity and you might have two PCs that are using that entity as a cost share. The problem with this is that the government has, based on the requirements of the CEWS program, the government has clearly said that the revenue test, so the revenue decline, must be in the same company as the payroll account. So in the case of a cost sharing arrangement, the cost sharing entity has the payroll account, but it does not have the revenue. The PC would have the revenue. So we have a clear disconnect here where the government has said that will not qualify. But we've been talking with our government, our team, and and the government team, and CPA also has a team working specifically on this cost sharing, because I think it's actually a matter of understanding. I think that the government doesn't fully understand the cost sharing structure in this case, and there are a lot actually in Canada. So we are working to provide specific examples to say, like, hey, like, this doesn't make sense that this shouldn't qualify. We should still be able to get in the program, whether we're going to apply at the PC side or whether we're going to apply at the cost sharing side. Just tell us where, but we must be able to apply somewhere. So right now, the answer to that is you can't apply. You won't qualify in either, unless you have your own payroll within your PC. But assuming that you're within the cost share, that it's probably not going to be lucrative enough in that case. So right now, honestly, you just have to wait. It's a waiting game right now until we see a change, if any, on the government's position on it.
Thank you.
Excellent. So just a final question here. If we provided a top up and now decided to hire staff back, like retroactively to the March 16th, how do you handle this situation generally, as far as like payments go? Again, would this just be something you'd work out with the numbers, with accounting? Are we going to reverse that top up, pay regular earnings, or are we just going to pay the regular earnings less the top up?
What do you mean the top up?
Well, let's say we've been topping up. Let's say we've been topping up our staff, right? You want to clarify that, Hisham?
Yeah. So we've been topping up. So there's two different types. We've been topping up our staff that are currently on CERB for or EI previously, before CERB was launched. That staff were being topped up that were on EI, and then come CERB, we decided to top up our staff afterwards as well. So now the question comes, if we're retroactively paying our staff, but at the same time we top them up that amount, where would we stand in this? Can we get that money back, or what is the best way to navigate through this?
So I think any amount that you top them up and you qualify, like if you qualify for the decline in revenue, the top up should still qualify because it's still wages paid. And then if you decided, I guess, to increase their pay back to March 15th, then that should also qualify under CEWS, and then they would need to pay back the CERB if they made more than the 1,000. So I would still see that as qualifying. Like in that case, there would actually still be employer-employee. There's still the relationship there. You haven't laid them off or anything. So yeah, I don't see why that wouldn't qualify in the CEWS.
Yeah, so just a quick question. So just so we're clear, so let's just say everybody that was on CERB, or ultimately if we put them on retroactively put them on CEWS, they're going to have to ultimately pay back the CERB amount that they were paid, correct?
Yeah.
But what about the employers that paid that $250 for a top up? Now, can we go ahead and say, well, we want this money back, or we'll put that towards some type of future credit or whatever?
Yeah, I'd probably have to look at that if you can put it towards a future credit. I'd probably have to look that one up and see if there's any guidance around that for sure. But yeah, I'm sure there is a mechanism to kind of make something work there. It wouldn't be lost if they're going to retroactively pay that employee for their wages, and then you've already topped them up. Then there for sure would be some sort of mechanism to actually make that work, but I'd probably have to work through kind of the accounting and the tax side of things to see how to actually make that happen. But I would fully expect that if they go back and retroactively pay them in full, that should be fine. And then we'd have to look at kind of the credit side of things for the top up.
Excellent. Well, thank you. That's amazing. So if we could just send off with a few just comments from each, both Melissa and Zoya. Just generally, you're a dentist, your staff are laid off, you know, you're in this situation, you're in our boat, you've been in the field, you've seen kind of what questions you're getting. And again, we all realize that individualized, advice is going to be required, but any general comments you can give to the dental profession, we got about 130 people still on here, as far as your recommendations to manage, you know, from a CRA perspective and an employment law standard. So maybe, Melissa, if you want to start.
Yeah, just from a CRA perspective, I didn't really touch on the audit side of things, but the audits won't be very onerous. They're all going to be phone-based by CRA. So I don't think people should be too worried about kind of what an audit looks like of these programs. If you're keeping things honest and not trying to manipulate anything, we're not really expecting that people are going to just fall into penalties where the CRA is going to impose anything that, you know, clearly you weren't trying to mess around with the program. But overall, I would just say, sorry?
I said, there goes Hisham's chances.
Overall, I would say like the program can be pretty lucrative. And if you are, you know, trying to help your employees out by giving their maximum amount, the government is really there and has been very vocal about rehiring employees and about supporting the employees. So they would much rather have people going through the CEWS program than the CERB program. You know, they've been quite vocal about keeping people out of the EI system, out of the CERB system even. And it's really about the employer retaining that employer-employee relationship. So they're going to be overly supportive, you know, in whatever you try to do, assuming it's above bar. So my suggestion to everyone is to, you know, really look at finances, really, you know, break down the numbers for each of your staff and see what you can do and see if you should retroactively or go forward hire. And, you know, there's not a lot out there that I would say is you should be too concerned about from an audit perspective if you're just kind of keeping things honest. So
excellent, thank you. And Zoya?
Sure. So I think we pretty much touched on a lot of the common questions that we've been receiving. And I think the main thing to remember is to be conscious of those sort of layoff periods. Review your contracts. I think your contracts will be the most helpful for you in deciding who is coming back and how to recall and what entitlements could be, if you have to make some tough decisions of who has to go, what kind of notice you have to give. So definitely reviewing those contracts, and like we talked about some of the changes that you might be wanting to consider in offering new contracts. I think those are probably going to be most helpful to you in this time. And then I think there's the legally important aspect, and then there's also a practical aspect that I think both Meniza and I touched upon, where there might be some things like, for example, currently a layoff may be a constructive dismissal, but an employee looking at market conditions right now may think that this isn't the time to pursue that, and let's see how we can, both parties can communicate to see how effectively they can get back into their regular employment with regular wages and hours. So there are some practical points to consider, and I think those will be, communication will be most effective in this time to help resolve some of those issues.
Excellent.
Thank you so much.
I just wanted to add one more point. Meniza did mention, she asked me to just mention to everyone, all of the media interviews are posted on our website, or you can follow Meniza on Twitter. She's pretty active. I don't really use Twitter, but you can follow Meniza, and all of her media interviews are posted there. So a lot of common questions that do come up are actually answered in there as well.
Awesome. Thank you so much for that, Zoya. And we did once again post Meniza, Zoya, and Melissa's contact information, so please feel free to reach out to them. Once again, we want to also announce that Meniza and Zoya are offering a 15-minute free consultation for anybody who is interested. Once again, guys, thank you so much for attending today. I'd like to thank Meniza Sheikh, Zoya Alam, and Melissa Avero for your time today and for your opinions and everything that you said resonates so far and deep with us. So thank you for your time today. It means a lot to us. Obviously, your guidance and your expertise was very well needed and it was incredible. I'd like to thank my co-host for the day, Dr. Azim Sheikh, for putting everything together, and he's the kind of the machine behind the scene. So thank you for everything, Azim. You've done a fabulous job, and you've been a great inspiration to the entire community. And I'd like to thank all of our viewers today for attending. Once again, we will be posting this video for anyone who missed it or came in a little bit later. It will be posted on our YouTube channel at the Dentistry Academy. So once again, thank you for everything. Enjoy the weather, enjoy the weekend. Have a happy long weekend, and have a great day.
Thank you, guys. Thank you.
Thank you.
Thank you.
See you guys.
Guys.